Now for what's trending in true crime. Charges have been upgraded against an Arizona father accused of leaving his 2-year-old daughter in a hot car for hours before she died. All of this while he allegedly was playing video games. 37-year-old Christopher Scholtes now faces felony first-degree murder and felony child abuse in the death of little Parker Scholtes. He told police that he left the girl sleeping in the back seat last month with the air conditioning on. Here's Craig Smith of Scripps News Tucson with the story.
Marana police say the 2-year-old girl died after the father left her in the back seat of the family car for more than 3 hours. The man told police that he left the engine and the air conditioner running, but he also knew that that car would shut itself off fairly quickly. The young girl died on July 9th. Marana police originally said Christopher Scholtes left the 2-year-old girl in this car with the air conditioning running, but the air conditioning shut off. He said he had left the child in the car before and did not want to wake her because she was sleeping. This is one of our own company cars, but it has a feature the car in this case had too. If you put this car in park and leave the motor running, the car will shut off automatically in 30 minutes. And police say Christopher Scholtes knew that. According to the interim complaint, the family's other children, aged 5 and 9, told police Scholtes often left all the children in the car, and on this day was distracted by a video game and by putting some food away. Scholtes' wife is a medical doctor. Investigators say she came home about 4 p.m. and asked where the 2-year-old was. The report says Scholtes searched through the house, then remembered the girl was still in the car. By that time, the car and its air conditioning had stopped. Police say by late afternoon, the temperature was 109. Scholtes told police he had returned home with the girl by about 2:30. Police found neighborhood surveillance video that showed they'd returned at 12:52, about 2 hours sooner. The child's mother tried to revive the child but could not. Police say as an ambulance rushed the child to a hospital, the mother texted Christopher Scholtes, "I told you to stop leaving them in the car. How many times have I told you?" Scholtes responded, "Baby, I'm sorry." The mother texted, "We've lost her. She was perfect." Scholtes said, "Babe, our family, how could I do this? I killed our baby. This can't be real." Craig Smith, KGUN 9.
Tragic story all around, and this morning we are asking why first-degree murder charges instead of the original charge of second-degree murder. Let's bring in our wonderful panel of guests. We have former homicide prosecutor Melba Pearson still with us, criminal defense attorney and former public defender Michael Riley, and retired DEA supervisory special agent Michael Wilhite Sr. is with us. Thank you all for being here and for breaking down this really heartbreaking story, but it's an important one. And Michael Riley, I want to start with you. First-degree murder versus second-degree murder, but it doesn't mean that he's any more intentional because it's felony murder. Can you break that down and react to whether or not prosecutors should have taken it this step?
Yes, thanks, Julia. It's great to be here. I think there's several factors that led to the charge getting brought up to a murder 1 as opposed to a murder 2. First and foremost, we're talking about July in Arizona, 109 degrees outside. Second, we know that Christopher Scholtes' vehicle was going to shut off. He knew it was going to shut off. It did shut off. And third, for over 3 hours, he sat inside playing video games and never went outside to check on Parker. Just a heartbreaking case, Julia.
So heartbreaking for everyone in the family. Michael Wilhite, can you talk to just the investigating part of this case? You have officers first knowing that there's a child that is deceased inside of a car, but they don't stop there. That doesn't automatically get them to thinking that this may be a murder case.
Right, Julia. How are you doing? You know, they're going to definitely look into cooperate as far as, and I think you already mentioned that in the prelude, that when he actually arrived, they're looking at cameras, you know, from the residence, from the streets and stuff to see when he actually arrived. They found that he drive 2 hours earlier than what he stated he did. They're gonna be talking to the other kids too to see if either there's a pattern. They discovered that apparently he's left him in the car before. Texting the apparently texting between him and the missus after she tried to revive the child. The search reflects that he's done it before, and they've talked about his pattern before. Also, they're gonna look at other. They're gonna look at talk to the neighbors. They're gonna talk to as far as if there's daycare or school officials. Check medical records and everything to see if there's a pattern beyond just him leaving the child in the car, the kids in the car.
Melba, Michael, well, thank you for that. But Melba, I want to talk about the human side of this, the parent side of this. You know that this is a dad who seems like he was truly remorseful, cannot believe that he did something like this. And a defense likely will be looking into distracted syndromes. Forgotten baby syndromes is one that a neuroscientist in the Justin Ross Harris case, David Diamond, brought forward, where there's a neurological part of it where this person's brain just completely forgets because he looked for her in the house, thought she was in the house at the time. But first degree versus second degree, your thoughts on prosecutors saying, no, we're going to go even tougher with this?
Yeah, and as a former prosecutor, I hate to say it, I think it's an overstretch. I think it's an overreach. I think second-degree murder would have been appropriate, as well as even possibly manslaughter. If I was charging it, I would probably charge second-degree murder with the option for the jury, if that is permissible in Arizona, as a lesser-included offense, to be able to pick manslaughter if they thought the facts warranted it. Based on the text messages between the husband and wife, you know, it sounded like, listen, he may not have been the greatest dad in the world, but it didn't sound like he wanted to kill his child. It doesn't sound like there had been abuse in the home. If that came to light, then I would have a different viewpoint. But it just seems, we have heard of this so many times before. I believe it was in Georgia where a man left his child in the car and then got on the train and went to work and completely forgot his child was still in the car seat, and sadly she passed away. So these things do happen. Yes, charges are appropriate, but I don't think he was intentionally, because this is a felony murder, you have the child abuse aspect, and then it was elevated to felony murder because of the fact she died. I still think it's too much. I think the family is grieving very deeply. I think he's very remorseful. This is, to me, a second-degree murder or a manslaughter.
Now, Scholtes has said, as we've mentioned, he had done this before. He left her inside of the car with the AC running and that everything was fine. But the complaint in this case reveals that at the time he was distracted by not only video games, but putting groceries away. That's what he told police. And so it leads us to ask, should he, if this goes to trial, if this gets to that point, should he take the stand in his own defense? Michael Riley, this is one of those cases, it's not a self-defense case where we often say it's almost you have to take the stand if you're the defendant. But in a case like this, where you have the wife, the mother of this child, fully supporting her husband, she pleaded for him to get bond, and he did, with the judge saying this was just a tragic mistake. Is this something that he would need to relay himself to the jury?
I think it's a strategy the defense should seriously consider. He likely has no criminal record. He can take the stand. I think a jury is going to have sympathy for him. He lost a child. His wife would likely testify as part of the defense case, and his testimony would likely to be consistent with that. Especially if the state is going to go forward with this murder one charge, I think he has a lot of incentive to get up on the stand and tell his story. And if this was maybe a negligent situation, a reckless situation, I think his testimony could help enforce that. And if not, get him an acquittal, which I think would be very difficult, it might support a finding of a lesser included offense like a murder two or a manslaughter.
Michael, will I talk about how public perception is of these cases? I mean, they are the headlines that grab people's attention. It breaks our hearts. But parents, if there are parents on that jury, do you think they will commiserate with him or feel much differently this tragedy that he was looking at video games, that he was putting groceries away? Are they going to be able to relate, or are they just going to look at him like a terrible, terrible parent?
I think it's going to be 50-50, Julia. You can have some that can relate to that. You know, hey, taking the groceries in, just briefly leaving the kids in the car briefly. I mean, you know, but also, you know, Arizona, you have the other aspect, other part of the jurors. They're like, hey, how could you do that? But I'll tell you one thing. There is no punishment that the courts can give him that he's not been already punished for right now. Just the mere fact that he lost his child, it was through his negligence, and that's going to just run through his mind, through his soul for the remainder of his years.
It's such a difficult case, but thank you all for weighing in on it, breaking it down for us. We'll continue to follow this story out of Arizona. Michael Riley, I know we have to say goodbye to you. Thank you for your analysis this hour. Melba and Michael Wilhite are sticking around.